Thank you very much. Good morning, everyone. It's my pleasure to welcome you to the 16th Annual Business Luncheon of SPA Ajibade Co, with the theme this year, Regulation of Legal Practice in Nigeria, Charting a Way Forward. We'll be starting this program with an opening prayer. Can we please pray? Father, in the mighty name of Jesus, we want to thank you for how you have helped us all throughout this year. Thank you for the first edition all the way to the 16th edition. We are grateful for your faithfulness. Please accept our thanksgiving in Jesus' name.
Amen.
Amen.
As we begin today's edition, or this year's edition, we pray that in your mercy you will keep us from evil. And we pray that by the wisdom of the Holy Spirit, we'll chart a great way forward. Thank you, Heavenly Father. In Jesus' name we have prayed.
Amen.
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 It's my pleasure now to welcome the managing partner of the firm, Dr. Babatunde Ajibade, for the opening remarks. Welcome, Doc.
Thank you very much, Kola. Good morning, distinguished ladies and gentlemen. Thank you for joining us for this, the 16th edition of the SPA Ajibade Co Annual Business Luncheon. As you may be aware, we've been running this program since 2008, and it's a modest contribution to the advancement of the legal profession in Nigeria. Over the years, we've tried to examine topics that we think would aid the advancement of the profession in Nigeria and elsewhere. And we've chosen speakers who will shed light on these knotty issues. Our various topics have touched on various aspects of legal practice, but I dare say that the topic we're dealing with today is probably the most topical of all. And in order to deal with this, we have a stellar panel of discussants, as well as a keynote speaker who needs very little introduction. I will not steal the thunder of our moderator, who will introduce the speakers, but just to let you know that I've had the privilege of reading the keynote speaker's presentation, and I can assure you that there's a lot in there and a lot to look forward to. The legal profession in Nigeria today is in a state of flux, I dare say, and I think perhaps it's also fair to say that the legal profession in the entire world is changing, especially with the advent of artificial intelligence and other things that are affecting legal practice. This session today will explore all this and situate Nigeria in this continuum and see what we need to do to ensure that we keep abreast of what is happening world over and also anticipate what might be coming, even if it hasn't arrived yet. So once again, I thank you for joining us for this 16th edition, and I assure you, you will enjoy every minute of it. Thank you very much. I will now hand over to our moderator, Mrs. Boma Alabi, Senior Advocate of Nigeria, OON. She likes to tell me that OON stands for Owners of Nigeria.
Right.
Thank you very much.
Thank you very much, Dr. Ajibade. And I call him Dr. SAN. So there we go. But yes, this is really an exciting topic. And thank you, SPA Ajibade, for putting this together, for being consistent. Every year we wonder how you're going to top yourself, and somehow you do. So it's really exciting. We have Chief Anthony Idigbe, SAN, PhD. So he's also a doctor. And I believe a professor. I'm not going to go through their CVs. I mean, for them to be sitting here, the CVs are as long as the day is long. So they're going to be putting all of that on stage, on the screen for us. So those who are not here with us, you can see they've achieved an enormous amount in the profession. That's why each and every one is an authority sitting here this early morning, shall I say, mid-morning rather. We also have the privilege of having my colleague, my brother Silkwick, conferred with SANs in the same year. Chukwuka Ikwuazom, who is a partner in Aluko Oyebode, A&O as we call them. Afam Osigwe is also same year as us, but he's on his way. He's had some challenges with logistics, and we hope that he'll be able to join us either online or in person. We have the privilege of my sister here, Joyce Oduah. Joyce is currently Vice President West Africa of PALU, Pan-Africa
Lawyers Union.
Lawyers Union. She served us as the General Secretary of the Nigerian Bar Association and served us in various capacities also within the profession. So it's a real privilege and honor to welcome you. And Tobenna Erijiokwe. Please pardon me if I don't pronounce the names correctly. I do my best. But Tobenna is also a very experienced practitioner, big heart for the profession, working really hard with our continuous legal education. I must say, same thing with Chukwuka. Chukwuka was my chairman of the Lagos branch. So we have a stellar panel, and I'm really looking forward to hearing from them. In the course of this program, we're also going to have online polls so that we hear from all of you here, both virtually, mostly virtually, what you actually know about this profession and regulating the profession. The topic is the regulation of the legal practice in Nigeria, charting a way forward. Are we actually regulated? Is a question I ask, because we have the privilege, Dr. Idigbe and I, of being dual qualified in 2 different jurisdictions. And I recall coming here to practice, I'm thinking, this is a bit of a Wild West. But I would take the, are we regulated? So the poll, the first questions, we're going to take 2, and then we're going to get the results literally as we go along. Please indicate which category you fall into. Are you a judicial officer, practicing lawyer, in-house lawyer, banker, accountant, other profession, law student, or other? So we'd like to know a bit about you. And then, who do you think regulates the profession? It's not a trick question. I actually don't know. Who do you think regulates the profession, the legal profession in Nigeria? Is it the Nigerian Bar Association? Is it the body of benchers? Is it the General Council of the Bar? Is it the Chief Justice of Nigeria and the Supreme Court? Or is it all of the above? So are we going to go straight into the poll now? The instructions will be coming online for you on how to participate in the poll. Don't be like me and think you can come back later, because you have to vote now or you miss the opportunity. It'll be going on for, oh, there you go. It's right up there. And we have quite a number of practicing lawyers in the room. And when I say the room, I mean the virtual room. So welcome to all our distinguished colleagues who are here with us and participating in this poll. I see a few judicial officers also. So welcome to my lords and your worships, as you may be. It's a pleasure to have you in the room, and we really value your opinion. Please, if there are any in-house lawyers, I don't see any there, do participate. If there are members here who are online, in the room with us, who are not in the profession, your opinion is welcome. Because when we're here to, when we practice law, we practice to serve you, the members of the society. Have we got the results of the poll yet? So the first was to indicate your background. And we can see we have quite a large number of practicing lawyers in the room. Welcome all. And the second is, who do you think regulates the legal profession? Like I said earlier, it's not a trick question. Is it the Nigerian Bar Association? Is it the body of benchers? Is it the General Council of the Bar? Is it the Chief Justice of Nigeria or the Supreme Court? Or is it all of the above? I have no idea. We shall find out in due course. Well, interesting. I'm not going to say what the majority are thinking right now. I want to hear more from everybody else. If you haven't responded to this poll and you're in this room, please do so now. Your opinion is important to us, very valuable. It tells us where we're at. This is going to be an interactive conversation and discussion. And therefore, your feedback matters. Who regulates this profession? The Nigerian Bar Association, Body of Benchers, General Council of the Bar, Chief Justice of Nigeria Supreme Court, or all of the above? Let's find out. We'll be getting the poll results shortly. I think the poll is about to close now. If you haven't, it is closed, oh dear. So sorry if you've not voted, because the poll is now closed. And I'm going to tell us the results. Can you bring it forward a bit more so I can see? Oh, wow. Interesting. We have a good number who said it is the Nigerian Bar Association. A much smaller number think it is the body of benchers. A slightly larger number believe it's the General Council of the Bar. No one thinks it's the Chief Justice of the country or the Supreme Court. Actually, the largest number of our poll respondents today think it's all of the above. So I retraced my steps when I said no one thinks it's the Chief Justice or the Supreme Court. All of the above includes them. Now, I don't know who's right. I don't know who's wrong. It is pretty opaque, or as I like to say, it's clear as mud. We shall find out what the position is and why we need to change where we're at, if we do need to change where we're at. Shall we move on to the keynote speech now? It's such a privilege, and I mean that, to have Chief Dr. Anthony Idigbe, Senior Advocate of Nigeria, speak to us on this topic. Why do I say so? Chief, as I call him, has been a practitioner here for many years. He looks much younger than he really is.
Just 40 years.
Just 40 years in practice. Can you believe that? 40 years in practice. And then he goes off to Canada and qualifies as a lawyer there and practices there and immerses himself in practice in that jurisdiction. So he's bringing to us a viewpoint from these two jurisdictions and beyond, because he's always actually also had an interest in regulating this profession, making it better for those coming after us. So Chief, without much further ado, please present your keynote to us.
Thank you very much. I'm moderator today. It's really quite a pleasure to be here. This is my second time of speaking at SPA Ajibade's Business Luncheon. I'm really so happy that you have sustained this program, particularly your focus on the legal profession. But to the best of my knowledge, all your business luncheon have been focused on the legal profession, and I think that it needs it, and you are playing a major role in driving the public discussion on how we can make our profession better. Just to start, I have this quote from the Supreme Court of Canada, and from an interesting case. And they said, the future is more important than the past. A canoeist who hopes to make progress faces forward, not backwards. There's no way you can move the canoe forward if you are facing backwards. I have been asked to speak of my experience, particularly as the chairperson of the Legal Profession Regulatory Reform Committee. And so essentially the context of my discussion today will be that particular work that we did. It will be the fulcrum of my discussion. And I would speak about the context of that work and maybe share a little bit about the membership of the committee, what our work methodology was, and then what we discovered from that work in terms of the rationale for change in the legal profession, and then what our findings were. And then I would speak about what we came out with, what the output of that work was, which is the Legal Profession Regulation Bill. I may tangentially speak about one or two other issues that were not part of, not directly our work, but we had to stumble through those ones, like the NBA Constitution, the NJC, and the Nigerian Constitution. And then I would then speak about what happened after that output, after that bill was drafted. Particularly, I would speak about another bill that was drafted by the body of benchers and the fallout from that. I will share some of the challenges that we faced. And in concluding, I would sort of like make suggestions on how I think we can chart a new way or continue to drive the reform agenda. So, in terms of introduction and context, the LPP RC was set up in December 2016, but we were inaugurated in January, 24th of January 2017, by the then president of the Nigerian Bar Association, A.B. Mahmood, the senior advocate of Nigeria. And the core mandate that we had was to review the current regulatory objectives and the regulatory architecture of the legal profession and advise on its sustainability to meet the requirements for what was perceived should be a robust, responsive, and independent modern legal profession in Nigeria. So there were about 11 terms of reference, but I don't need to go into the details because I have a very short time. But one thing that was clear was that there was concern about the falling standards in the legal profession and the need for, therefore, a robust and responsive modern legal profession in Nigeria. So in terms of the falling standard, it was obvious if you read some of the then recent at that time. Remember, everything I'm talking about is with respect to the work we did in 2017. There were some judgments of the Supreme Court that even the grammar was appalling. So, and then of course, there were lots of complaints from the public on the conduct of lawyers, ethical standards, etc. Another thing that the context was the increasing globalization or global competition in the provision of legal services. And as at that time, Nigeria had signed the WTO protocol on the free movement of legal services. So there were fears and concern about what the impact of that would be in Nigeria. Again, we know that even as at today, that foreign legal firms are taking out most of the legal work in Nigeria. In fact, the majority of legal work of economic value, like big transactions, project finance, because the funding is coming from abroad, you find that a lot of legal work is going out. So there's competition. And then, of course, there's the question about how we can compete and how we can consolidate, in other words, grow big law firms in Nigeria, which is the issue of consolidation, in order to be able to compete because of economies of scale. You need economies of scale to be able to compete globally. And of course, there's the fact that clients' needs are changing. The sort of things that clients want are beginning to change, and there's a question about whether legal practice is actually ready for that. And with the setup of the Federal Competition Commission, there's the issue about, and although it hasn't come to fore, but it probably at some point will come, about whether we should continue to enjoy a monopoly in provision of legal services. Because essentially the profession is a monopoly. And then what will be the standards when they finish with issues about consumer protection and then they begin to go into competition law? Usually they will look at all the monopolies, and one of the monopolies will definitely be the professions. And a lot of consumers demand that monopolies should be regulated in such a way that it shouldn't be, they cannot form cartels and then have price, basically to control price of the consumers. So the committee was made up of 30 members. There were lots of young members, and that's the list of the membership. We had people like Mrs. Adekoya, senior advocate, Ato Okafor, Usoro. Many of them have become president of the MBA. Very strong membership that we had. Lots of academia. There were people from body of benchers who had representative. Council of Legal Education had representative. It was quite a comprehensive committee. In terms of our work methodology, what we did was immediately after we were inaugurated, we then issued a call for memoranda, which was published in different newspapers. And we did receive a lot of memoranda from different institutions, including even the body of benchers, Council of Legal Education, the law teachers, so many, and private individuals also sent a lot of memorandum. So we then had our meetings. Usually we have the meetings and we debate, we do research, we debate on the issues, we research on what is happening in different parts of the world. We brought in the British Nigerian Law Forum, and other foreign practitioners were involved. They sent members to the committee. Then we broke ourselves into subcommittees. So we had the current state subcommittee, which was headed by Mrs. Funke Adekoya, Senior Advocate of Nigeria, and then the future state subcommittee headed by Professor Ernest Ojukwu, Senior Advocate of Nigeria. We also had a job creation subcommittee, which was headed, which they didn't have a head, but it was all the young lawyers. And they did a fantastic report, not directly focused on the issue of regulation of the legal profession. So I may not say too much about that. And then we did a stakeholder consultation. So we went around the country. We had one in Lagos, Kaduna, and Calabar. So we had town hall meetings. We had retreats where we engaged with different practitioners from around the world. We did a literature review. We, looked at the different systems, and eventually the subcommittee submitted their report. The idea was that the current state subcommittee was to do an analysis of our existing system, identifying the gaps in the system, and then the future state subcommittee would then design the future state that we perceived or that we conceived for the regulation of the profession. All that was done. We had plenary, and then we eventually came out with a draft bill and submitted our final report May 17. So just in terms of the context of the sort of work that we did, by October, we submitted our report in May 2017. By October, the IBA did their own review and submitted a report, the IBA report. And then they identified certain drivers of change in legal services. And it gives sort of the international context for us to understand also the work that we did in May earlier before the IBA. And they said there were about 6 factors or so that were driving change in the legal profession. One was the changing demographics and values of people, as population is changing around the world, and also the economic situation of the people are changing. Looking at, emerging countries, newer countries, India, China, Africa, skills mismatch and legal education reform. So as these changes are occurring, there's sort of like a finding that lawyers no longer have the skills that the clients need. And so there was a gap. Globalization and shift of economic power. Again, this speaks to the fact that you have new countries like China, Southeast Asia coming up very strong economically, and that was affecting, who determines the play in the legal field. Then you have the emergence of new forms of value creation, the sort of like Uberization of legal practice and such legal technologies, or people who can come up with new ideas of how services can be given that could basically displace law practice. So you have legal technological developments and innovation again coming in, and then you have regulatory innovations and gaps. So this was in 2017, October, and this report came after our own report. So let me speak a little bit about our own report and the context. First was that in 2017, there were 120,000 lawyers in Nigeria enrolled in the Supreme Court to practice, and that included all the dead ones as well. So, and we found that those that were 0 to 7% were 42,704, so which was 35%. And if you check that, it was most likely that the proportion of those young lawyers who were alive was very high. And whilst the proportion of the others who were alive were not as high, it meant that actually this 35% I'm saying may not be the true reflection. It's possible that the young lawyers were up to 50%, because as I said, the 120,000 lawyers were both the ones alive and dead. And the problem is that in Nigeria, there's no diversification. So everybody comes into legal practice. And then you are both a barrister and you are a solicitor. So you don't have the sort of diversity that you have where, compliance, and so many other things that require lawyers in other jurisdictions exist. Everybody comes and everybody wants to be a practicing lawyer. So that was one of the problems. And in any event, as I said, we did a lot of literature review and we were trying to look at the basis for the regulation of law. And we found that very long ago, some people had found or argued that the cause of all misgovernment in any country is the maladministration of the laws in the courts of justice. This was a statement that was made by William Blake in the assembly in Canada in 1849. And then you can imagine, whether that is true today, that the cause of all misgovernment is just the maladministration of the laws in the courts of justice. Put it within the context of Nigeria today, it would seem as if the same statement is still very relevant, even as at today. And so the question is that it automatically means that to stop misgovernment, you just have to administer the courts well. And it means that those who administer the courts are the lawyers, and that those lawyers must have the competent skill to do it, and they must have the ethical standards to do that job. And that if you get that right within the courts, you will prevent misgovernment. But there's a question. Some people argue that, well, you really don't need lawyers anyway. Why do you need lawyers to deliver justice? Other people can do the same thing. And actually, the people themselves can do it. They don't need lawyers. You can just go to court yourself and argue your case. Be what we call citizens advocate. They advocate for themselves. And they say it will be cheaper, and it will be populist, And actually, when we did the research, we found out that in a country like Ghana, during the Rawlings Revolution, they actually had a true revolution in Ghana. And they disbanded the courts. And then they went to all the lawyers' offices and burned their books. Because they blamed the courts and the lawyers for their problem in Ghana, for their maladministration of the country. And then they set up citizens' tribunals where the citizens themselves decide the cases. And that went on for 10 years in Ghana before the profession came back. We do have warning signs in Nigeria if we do not drive reform. I only just need to tell you about the is it NSAS? Yeah. So where did the people attack as a reprisal? They didn't attack the police. Where did they attack? They attacked the courts. So it's a little bit of sign for us that there's a rationale and imperative for reform of the legal proposition, legal profession. So the truth is that on the other side, it's been argued that the formal court system and the legal profession has efficiencies which outweigh the cost and the other shortcomings that we have, So although the cost of maintaining lawyers and the layers of courts, appeal courts, etc., may be much, at the end of the day, that it increases the chance of getting justice. And So that's why, if you fail in the lower court, you may go to the Court of Appeal and the Supreme Court. The chance of getting justice is higher, provided that such a formal system of justice is imbued with well-trained personnel using well-established procedures and processes. So all those things they taught you in school, the principles of law, principles of equity, the interaction between them, and just how the system will work. So what we need to do, therefore, is to ensure that our personnel, or our lawyers, are well-trained and have the ethical composition to offer the public the desired service, which is justice. So it means that we must appraise our system from time to time, both the structure and the processes, to ensure that we are ready for the future and to prevent our profession from other contending and disruptive technologies and ideas, like the Uber has done to the taxi business. As at this time that we were doing this job, actually, we saw an advert in the newspaper by Union Bank asking people to walk into any of their branch to get their will done and do probate and things like that. We saw something similar from another company called Cardinal Stone, also, the Bar Council, Legal Practitioners Disciplinary Committee, the Supreme Court, the Chief Justice of Nigeria, the Legal Practitioners Privileges Committee, the Council of Legal Education, the Nigerian Law School, the Nigerian Bar Association. And there's no central organization or body or bodies, and none of these were subject to any central control. None of all these different bodies are subject to central control. And we found that the NBA has both representative and regulatory roles in the profession. For instance, we found that there's no licensing or supervision of practitioners and law firms. So, for instance, there's no annual practicing fee license, no annual practicing license, no inspection, no insurance, no mandatory continuing professional development requirement, no annual report requirement. And we found that the MBA chartered CPD program has no statutory backing. So there's no express character or fitness guidelines for candidates for call to the bar. We know that they do go to body of benchers to sign something, but there's no express one. And the body of benchers we found as an institution is unwieldy with over 100 members. Too many of them are judges. So from what we call the official bar, they have 36 attorney generals and one federal AG. And you have to remember, against the background, that when the law was passed, there were only 3 regions or so, right? So it now multiplied to 36 and just blew up the membership. So there were few lawyer members, and even those lawyer members, and when I mean lawyer members, I'm talking of the normal bar, not the official bar, the unofficial bar. So and they are not directly elected, but are appointed. So there's cronism. So you then achieve regulatory capture and cronism. And of course, there's no term limit. So everybody's dream is to become a life bencher. And that blocks the way for anybody again for the next 40 years, you know. So, so the Honorable Attorney General chairs the General Council of the Bar, and consequently, being a political appointee in the chair, the Bar Council has not met in over 20 years, and new regulations don't come out from it. Now, you have to bear in mind that in other societies, you would find that you don't have it that way. The Attorney General doesn't chair the General Council of the Bar, and that it was a colonial, from our research, where they didn't trust the local people, and they felt that, okay, so the colonialists being in charge of being the Attorney General automatically would chair, and we've just carried that tradition, which is colonial, up till today. But if you go to England, you know that the Treasurer is the head of each of the Inns of Court, and in Canada, that's what was just replicated exactly how it's supposed to be. So go to the next slide, please. We found out so many things, but I need to move a little bit. So based on our findings, as I said, that we had the Future State Committee, so they came up with a new bill by which we try to now fill those gaps. And essentially, we resolved that there was a need for a new legislative framework. And we came up with a Legal Profession Regulation Bill, which was drafted to reflect the proposals of the committee. And that bill is made up of 9 parts with 103 sections and 3 schedules. And it was to repeal the Legal Practitioners Act and the Legal Education Consolidation Act, and enact one comprehensive single legislative framework for legal practice and education. So that's the Legal Practitioners Regulation Bill. In terms of the details, it sets regulatory objectives in Part 1. Part 2 deals with the establishment and composition, functions, powers of the Legal Profession Regulation Council of Nigeria, which will then become the new institution to regulate the profession. Part 3 now deals with the general provisions relating to practice of law. And then Part 4 deals with the establishment, composition, powers of the Council of Legal Education. So there will be basically 2 institutions, the Legal Profession Regulation Council of Nigeria and the Council of Legal Education. And then it talks about the regulation of legal education providers, because we found that there was a need for that we can't rely on the government to keep training lawyers. So we wanted a need to privatize it. So there will be legal education providers who will get licenses to run law schools and things like that. But we then still made provision to keep the Nigerian law school. So the government will still continue to provide if they wish, but we'll allow, just like what you have with private universities and government universities. So that's the whole idea. Summary, the bill would have established one apex organization that would regulate the profession. And the composition of the Legal Profession Regulation Council of Nigeria is done in a way that it will guarantee its independence, and the NBA will play a strong representative role. And the funding of that council will be by way of the legal market. So the lawyers will fund the council and not the government. And it reduces the risk of regulatory capture by making provisions for direct election to positions, and involvement of lay persons was introduced under the bill in the regulation of the profession. And it's likely, therefore, to meet, because it's independent, it's likely, therefore, to meet the requirements of the Federal Competition Commission. And then it imposes term limits. So although if you are already a live bencher, you can keep your live bencher title, but the maximum you can serve will be 12 years under the new regime if it came. So then there are various committees that were to be set up under that particular law. The body of benchers will remain as a committee for call. There will be the Professional Conduct Committee, the Legal Services, Ethics and Standards Committee, the Legal Aid and Welfare Committee, Governance, Risk and Audit Committee, Compliance Enforcement Committee, Education Committee, Young Lawyers and Career Committee, and Privileges Committee. So the technical and intellectual competence of lawyers will be maintained through the mandatory statutory CPD program, which was introduced under the bill, and that would have helped the MBA program to actually transit to a statutory regime. And then there will be a laboratory system of supervision of lawyers to address the issue of integrity and ethics in the profession. And then it introduced a new category of privilege, which is the certified specialist. So one of the things we found is that the desperation of people wanting to become SAN was actually devaluing the profession. Even at the last conferment, they still made comments about it. What do we do to make sure that people are not bringing up a lot of litigation just because they want to be SAN? And so we suggested that the idea of certified specialist as another route for people to get recognition. So it also then provided for the licensing of law firms. That would eliminate some of those issues that we saw where a case of 20, 30 years, and then they say that the person who signed the name of the firm, and so there'll be licensing of firms. And depending if you get to the issue of regulation, so if you do regulation, if you say regulation is risk-based rather than deregulated, for instance, then you could use that to encourage consolidation, so people coming together, etc. There was privilege was also introduced, etc. Let's just move a little bit faster because of time, and since we will have a Q&A session. So there are issues, a lot of issues we found that we are confused about. So, and it even came up recently at the Supreme Court, the conferment ceremony. One of the questions is the leadership of the bar. Who is the leader? Is it the Attorney General or the NBA president? And who chairs BOSA? And then they were speaking from two sides of the amount. If the Attorney General is sitting down there, then the Attorney General is the chairman. Otherwise, the oldest BOSAN member is the chairman. So you see this issue about official bar and unofficial bar, which we trace to colonial history. Simply that they didn't trust the locals, and then because they were in control of the official bar, as it were, then they kept insisting that, the official bar is the one that is priority. And we are still stuck with it till today. So there are lots of issues about MBA, the branch system, sources of finance for the MBA, etc. I want to skip all this because I want to focus more on the regulation of the profession. So, having done this job with all this our work method and the rest, the bill was remember I told you that body of benchers were members of our committee, and they were part of it. We argued everything together. They were there, Then suddenly the issue came up that the bill has cancelled the body of benchers. And we said, okay, let's engage. We're to go and make a presentation to the body of benchers. And they said, okay, the chairman of the committee knows about the bill, can answer all the questions. Let him come. They say he's not our member, he can't come. That the president of MBA should come and present. He went and presented, where we got stuck into all sorts of things. At the end of the day, the body of benchers came out with another bill. They submitted it to the National Assembly. They took one or two things from the work that we had done, but it was not deep, And then the bill was slated for public hearing. At this time, one of the things that we found was that I remember after the tenure of A.B. Mahmood, the MBA, people were coming to me and the MBA got in touch with me and said, the tradition is that every committee collapses with the president. So the tenure of the LPP-RC had expired. So I stopped responding. The people want to call me once, I would stop responding. And that is one of the issues. But eventually, Mr. Akpata did call on me that I should come and help them at the National Assembly. So I then went to represent both Bosan and now to support the president of the Bar Association. And we were able to show that the bill of the body of benchers didn't go through the same process that ours went through and didn't deeply address the issues. So you see some of the analysis. The BOP bill had no regulatory objectives, no harmonization of the multiple regulators, no independent apex regulator, no term limits. It was still controlled by official bar, no direct representation. Funding is by government instead of the lawyers themselves. Did not deal with the provision of legal education, no term limits, etc. So the body of senior advocates actually did an analysis and they identified 28 differences between the BOP bill and the LPPC bill. And so we successfully opposed the passing of that body of benchers bill. Senator Bamidele did a fantastic job trying to bring everybody together. So I'm forming a committee to work on harmonization of the position of body of benchers and MBA. And we did produce what I would call a compromise bill, which we now call the Benchers and Bar Regulatory Council Bill. Essentially, it remains the MBA bill, but with the name of the apex body changed to satisfy the sentiments of the body of benchers. So, now where that bill is now, I don't know. LPPRC has expired. And in terms of concluding thoughts, MBA in 2021 did another research. And they found again that there are certain issues that are shaping the global legal ecosystem and are driving change. And that will include things like discrimination, legal service redesign, legal technology, internationalization, which I had mentioned partly before, WTO protocol, and now we have the African Continental Free Trade Agreement, the need for additional skills to fill those skill gaps that I mentioned earlier, training solutions, controversial approaches to regulation, whether it should be risk-based regulation or whether it should be deregulated. I can speak more on that. But that having been said, what's my hope? What's the future? I want to rely on what Sir Clementi, who ran the reform process in England, said, where this was in December 2004. And I quoted him here. He said, reform will not be easy. Whilst there's pressure for change from consumer groups and also from many lawyers, reform will be resisted by other lawyers who are comfortable with the system as it is. Lawyers who are opposed to the reforms in this review, we either argue that I am mistaken and have failed to understand the special characteristics that set the law apart, or call for further research and consultation, kicking reform into the long grass. Changes will require significant political commitment, partly to meet the expected criticism from some lawyers, and partly because reform, we need primary legislation, which requires scarce parliamentary time. So I think that there's a lot that you will find in what he has said: political commitment, the need for a primary legislation, the need to fight at the National Assembly. Like we fought before to kill one, but we need to fight to install a new one. I would like to just share a small video of thoughts about the legal profession, and the future.
Legal education and legal practice need to respond to the current challenges of a global and a digital society. In the Middle Age, in Bologna, which was one of the first universities in Europe, the way they taught law was what was called jus commune, which was principles of law that were actually not applicable to one specific country. And then with time, other universities in Europe and around the world started teaching more national law, a more local approach. Legal education today is going back to the very origins. Well, the main legal systems are common law systems versus civil law systems. Common law systems are systems followed in countries like the US and the UK, which are two of the most relevant legal markets. Civil law systems are followed in continental Europe. In order to be able to practice the law in this complex world requires to truly understand more than one legal system, more than one jurisdiction, to serve and to give a quality service to international clients or even to national clients in international deals. Global legal practice responds to the internationalization of companies, of countries, to the European Union harmonization, to movement of people and services. But there's another force pushing for change, and this is the use of technology and digitalization, again, of services and digitalization of companies, business, and governments. Current society challenges from the pandemic to the war in Ukraine to climate change, international disputes or international acquisitions or international deals. Any transaction, not only by multinationals, but also by small and medium-sized companies, needs some international advice. There is a need for all of the parties to at least understand to a minimum level what the legal system from the other party is like. Because business transactions are happening online, conflicts are arising from a different way of signing contracts, from a different way of selling goods, from a different way of providing services. The challenge, I believe, is the access, so the regulation to actually acquire the qualifications to become a practicing lawyer. This is still locally regulated, versus the trend for a response with international legal services. Talented students around the world are looking for more international opportunities, or at least looking for opportunities where they do not need to decide from scratch where will they practice their profession. I imagine an education that responds to society, not to the regulation required for the qualifications for the profession. And the true needs of society are the needs to give legal services to a global and to a digital society. Lawyers who will shape society need to think globally, need to acquire what I call a global legal mindset, because lawyers are the architects of society.
Thank you. Thank you so much. I think that summarizes what the issue is. What's the mindset that we need today to move our profession forward and to continue to be relevant? It's not just to be relevant locally, but to be able to compete globally. I would just like to ask the question in ending: why are we so afraid of change? Heraclitus, the Greek philosopher, made the assertion that life is a flux, pantare in Greek, meaning everything and all things change. So why are you afraid of change? Because everything will still change anyway, whether you are afraid of it or not. Nothing in this world is permanent. The only thing that is permanent is change. Thank you.
Excellent. I mean, I did say that you were interested. I found it absolutely fascinating. I'm sure it was the same for all of us in this room, physically and virtually. And Prof, please, I've moved from doctor to prof. Well deserved. So what I took away from all of this is, yes, you said you don't paddle a canoe by looking backwards, right? But then, if you don't look backwards, you don't know where you're going. It's one of my favorite authors, Maya Angelou, who says, I have great respect for the past, because if you don't know where you're coming from, you cannot know where you're going. We have this colonial history, which has really been part of what shaped us for where we are now. And we understand that. We then have to see how we're going to make it better. I won't say much more because we're very short of time. I'm going to ask our main discussants to start with their discussion, starting with my learned friend of the silk, Chukwuka Ikwuazom, Senior Advocate of Nigeria. Please.
Thank you very much. Is it morning or afternoon?
Literally just turned afternoon, 12 o'clock.
Okay, good afternoon, ladies and gentlemen. It's my pleasure to be part of this conversation. And I would like to thank the leadership of the firm of SPA Ajibade Co for the consistency that the firm has shown in leading these conversations to make our profession better. I would like to thank Chief Idigbe as well. I hadn't read the bill, the legal profession regulation bill, until I got invited to this event. And I took time to read it. It's a wonderful piece of draft legislation. And if you asked me now to answer the question, how do we chart the way forward for the profession? I would say that that document presents, the foundation that we can build on, in regulating the profession in the future. As part of my intervention, what I propose to do is not repeat what has been said by Chief Idigbe, but share my experiences. My learned friend here of the silk, when she was doing her introductory remarks, said that she and Dr. Idigbe are the two people who are qualified in other jurisdictions. I'm also qualified beyond Nigeria. I'm admitted as an attorney in the state of New York. So what I intend to do is, share my experiences. I'll be focusing on 3 or 4 things. The first is where we actually started this conversation, which is who regulates the profession. I think it's a big if, because what we have, sorry. Is it better now? Okay. So what we have at the moment is very disjointed regulation of the profession. We have multiple bodies and organizations, the body of benchers, the General Council of the Bar, the Nigerian Bar Association to an extent, the LPPC that has responsibility for the award of the rank of Senior Advocate of Nigeria for disciplining people who wear that rank. That's not what you have. That's not best practice. So if you asked any attorney in the state of New York who regulates the legal profession in that state, the answer will be nobody's going to be writing all of the above, right? Like we saw in the post that we conducted this morning. Everyone will tell you it is the appellate division of the Supreme Court of the state of New York. If you asked anyone in England who regulates barristers, they will tell you it's the Bar Standards Board. If you asked who regulates the solicitors in England, they will tell you it's the SRA, right? So I think that the starting point is we need to streamline the bodies and the organizations and the agencies that regulate the profession. And when we talk about regulating the profession, we're talking about 2 primary things. How do you set the standards for entry into the profession? And how do you set the standards for people to remain in the profession? So it's all about entry into the profession and remaining within the profession. Now, when you talk about entry into the profession, I think the focus is on legal education. Again, what we have at the moment is we have the Council of Legal Education, we have the Nigerian Law School. If there's any attempt at all to regulate legal education by these bodies, that attempt starts when people are coming into the law school. I think that it should start way before people get to the law school. It's setting curricula for university education, licensing people. And Dr. Idigbe said it, that was one of the innovations that I saw in the bill when I read the bill, and I thought it was a fantastic idea. People who provide legal education should be regulated. The mode and quality of examinations that people sit for, even at the university level, should be regulated. The qualifications of people who teach, in institutions that award degrees in law should be regulated. And then when people get into the profession, mandatory continuing legal education is very essential. My brother here, Tobenna Erijiokwe, is doing a fantastic job with the ICLE, but as Chief Idigbe mentioned, there is no statutory background and there's nothing mandatory about it. So, like I said, I'm an attorney in the state of New York. I don't practice there. I practice in Nigeria. But every year when I want to renew my practicing license, I have to answer questions about mandatory continuing professional development. So it is something that we need to, take very seriously here, because I always say to people that there are two things that we sell as lawyers. We sell our skills and our time. So if we do not continually update our skills as lawyers, there's a very big problem. The other thing that is not very obvious, but I see it as a problem, is, people are shaped and evolve by the circumstances in which they live. So when we talk about evolution, it's not just about concept in biology. It's something that applies in other spheres of life, including law. So you find that our jurisprudence in Nigeria is essentially driven by procedural law. So if you bring a lawyer in Nigeria and maybe his contemporary in Singapore or the UK or even in the US, you see that when it comes to substantive issues of, law, the Nigerian counterpart is obviously lagging behind because of this culture, this focus on matters of procedure. And I think it's something that we need to change. I would like to talk briefly about decentralization, what I describe as decentralization of the disciplinary process. So again, I go back to New York, right? 10 counties in the city of New York have what we call three complaint attorney grievance committees that hear complaints against attorneys in those 10 counties. In Nigeria today, if you want to complain against the conduct of a lawyer and you're practicing in Ebonyi State, you have to send an application to the LPDC in Abuja, right? And each time there's a hearing, you, the complainant, and the lawyer you've complained against will have to fly to Abuja to be able to answer to that complaint. And then the process can take for as long as 2-3 years. And then when a direction is made in the final analysis and you appeal against it, obviously the law is that the direction will not be implemented until we've exhausted all right of appeal. Appeals lie directly to the Supreme Court and may take 6-10 years. So what that does is that, if we want to inspire confidence in the profession, we need to let the users of the services that we provide know that if there's a complaint against a lawyer, that complaint will be dealt with expeditiously. That's not what happens at the moment. And then there is what I call the culture of fear and silence that is driven primarily by the system of privileges that we dispense. So there's a lot of subjectivity in the system of dispensing privileges. And that's what encourages this silence of people don't want to, culture of silence. People don't want to speak out because they feel that if they do and they apply to become senior advocates of Nigeria, because of the subjective element in the process, they will be punished. So that's one thing that we need to take care of if we're talking about really building the kind of legal profession that we want to see. And again, there's also, talking about privileges, there's also this preference for quantitative over qualitative assessment, which I think Chief Idigbe mentioned it. People are bringing all kinds of cases, to court because they want to just meet the numbers. I'm looking forward to a time when the assessment for the grant of privileges within the association will move from being quantitative to qualitative. So if you want to become a senior advocate, for example, we said to you, like it happens in England, give us your 7 best cases. You don't have to have appeared before the Supreme Court, right? Give us your 7 best cases, and those are what we look at, and then decide whether you merit the privilege or not. How much time do I have? 2 minutes. Okay. And I liked the idea of these certified specialists that the bill is proposing. Why do I like it? If we do not want to implement it, then I think that we should limit the privileges that are accorded to the rank of Senior Advocate of Nigeria to the courtroom, right? Because as long as those privileges continue to extend beyond the courtroom, there will be quest for people who are not even litigators to want to become a senior advocate. So you go for an MBA conference, for example, and there's a long queue, and they say, okay, this queue is just for senior advocates and for judges. And it doesn't matter that the non-senior advocate who is there is a very well-respected, very senior member of the profession. And my inquiries actually have shown that this dissuades a lot of people from getting involved in the affairs of the profession. So it is either we create this category to recognize people who have distinguished themselves in areas other than litigation and dispute resolution, or we limit the privileges that are accorded to the rank of Senior Advocate of Nigeria to just the courtroom. I think I don't want to exceed my time, so let me just keep it here for now. Thank you very much.
Thank you so very much for that absolutely brilliant intervention. And I have to say, you're not one of those who's afraid of change.
No, I'm not. I'm not at all. I'm not.
So that is fantastic. We have Mazi Afam Osigwe, Senior Advocate of Nigeria, online with us. He was supposed to be here in person, but like I said earlier on, he had challenges with his logistics. But he's managed to join us online. So I'm going to give him the opportunity to make his intervention before we come back to the panelists in the room. Mazi Afam Osigwe, Senior Advocate of Nigeria, you're welcome. Please go ahead.
Thank you so very much. I guess I'm supposed to speak generally on the presentation by Chief Idigbe. Or would you want to direct me to any particular area to speak on?
I shared my question with you and all the other panelists.
Hello?
Do 10 minutes on that. Your personal view on that presentation and your opinion is what we want to hear.
Okay, thank you so very much. I like the idea of having a wholesale or holistic proposal to amend some of the laws that regulate the legal profession. The Consolidated Legal Education Act, Legal Practitioners Act, and some other
sorry, Mazi,
my initial thought about it is that as good as some of the proposed reforms are, I think also requiring that the lay members of the... Yes, please.
I was going to say your connection is extremely poor. So I'm going to give you an opportunity to rectify that. I'll come back to the panel.
I may not be able to make it better than it is.
Says a real advocate. Okay, I am persuaded, advocate. Please carry on. Turn off the video.
Now, what I'm saying, I like the idea of reforming, having holistic reforms. But I'm afraid that packing some of those reforms, like trying to whittle down on the powers and involvement of the body of benchers, would engender some form of opposition from those judges who presently dominate it. And I do not think it's a good idea. I don't think a body of benchers that has every presiding justice, every justice of the Supreme Court, every attorney general, and then so many persons as members makes for an effective body of benchers. But I also think that we should look at an amendment that would get the buy-in of stakeholders. Now, Leonard Boma, Alabi, you're a member of the body of benchers, and you know that the difficulty has been in getting a consensus between the bar and the bench in agreeing on what version of that proposed bill that will be taken to the National Assembly for discussion. And if you also look at the issue of discipline, I think that not much improvement has been made in that regard. There's something to be said about a proposal which retains the current scheme of discipline that involves inviting every person against whom a disciplinary matter has been, a complaint has been made, a prima facie case has been made to Abuja to defend themselves. I thought that should have been a decentralization of that so that the panel can sit either in the geopolitical zones and then also put in some kind of fast track to ensure that these matters are dealt with expeditiously in the course, and also the appeal process. And I also thought that retaining the provision that says that once you appeal against that decision, it cannot be enforced, without stating that you must have a certain number of time to compile your record of appeal and ensure that those appeals are heard quickly, calls for a second look. Now, if you look, there are cases, appeals that have been filed to the Supreme Court that as at 2023, maybe since 2015 or 2016, no record of appeal has been compiled, or those that which have been filed have not been scheduled for hearing more than 5 years. And these are disciplinary issues, and members of the public are watching, and their confidence in the association will be greatly affected by how seriously we take issues of discipline. And I also think that the emphasis on having too many senior advocates in some of the committees makes it look as if there's an attempt to give senior advocates an upper hand in some of these committees. And we should look at them to ensure that there's an even distribution of membership or involvement of lawyers. And I fear that some of the proposals in that bill, the MBA version of it, which requires most things to be by election, may bring us into the current MBA political debacle that we have, where the MBA or lawyers, and I'm not saying I'm not guilty of it, we seem to be copying the society in the way we campaign for offices, in requiring that membership of certain committees should be by election, may actually create more problems than it solves. And also without stating who conducts those elections and how those elections will be conducted. I think also that bill has not gone.
It appears we have interference in the network with Mazi Afam, but we have an interference with his network. But fortunately, we do have I'm getting the directions from our technical chaps.
From money generated from CLE, part of it from money generated from donors. That one I find very strange because, again, on the one hand, we talk about independence. On the other, we are expecting money from somewhere outside, perhaps the legal profession. I think we need to look at that very closely. The second one is I am a big fan of post-education qualification training, both for PPAs and whether you call it training contracts. That's something I was used to when I was in England, supervising people who were doing their training contracts. And I know the big value they took from it. In fact, 2 years, you don't really sign anything. 3 years, you're still under supervision. And that helps your growth. But we come back in Nigeria and we don't have those kind of systems. Now, even when we want to implement that, it will require a whole lot of political will because it wouldn't be every firm in the marketplace that will be able to take on people and actually train them. So you have to regulate the firms to ensure that they have the capacity and the capability to train people. And what that will mean is that you could graduate quite a number of people who don't end up qualifying. And the other point to it is that we need to look carefully about the numbers. And Chief said in his paper about 6,000 graduating every year. That's a big problem. We need to think about it and think about it very creatively. Now, going to the main point that I was asked to talk about, which is encroachment by foreigners into our territory. Chief made the great point that a huge chunk of our income or income that should go to Nigerian lawyers actually goes to foreign lawyers already, even though there's supposed to be a war that doesn't allow them to practice in Nigeria. Now, I was part of an SBL committee that dealt with local content board, LLNG and other bodies about the actual spend that goes to foreign lawyers from Nigeria. I was also interestingly a part of an MBA committee that looked at the legal services incursion from England. So state government is trying to negotiate a trade deal with Nigeria. And then, funny enough, they have a clause in the original document that says that legal services must be part of that. And they went as far as the Bar Council and Law Society went as far as saying that what they actually want is what you call a mutual recognition of qualifications. So that you, Rakiba, or you, Nonso, who has always wanted to practice in England, you wake up and now have the right automatically to practice in England without taking any exams or whatever. So, and we find this, 2 minutes. Okay, so I find this strange because I know that what the terrain out there is like. And I take a completely protectionist view of this. However, I would just quickly say that globalization is something that we must confront. We must become more competitive, whether we like it or not. It's come to stay. Liberalization is also a big issue. And this came again from the Clementi Review when they started recognizing multidisciplinary practices, where estate agents, lawyers, accountants, and all could all practice under the same roof. Because I don't have a lot of time, I always like to at least say something impactful before I go. Does anyone really think that if you import all the lawyers from England to Nigeria, the system will not work? And that if they take the lawyers from Nigeria to England, the system will work? Thank you very much.
Thank you so very much. Ending on that interesting question, which I'm actually pondering as I speak, I'm going to immediately hand over to Mrs. Joyce Oduah to make her intervention because of paucity of time. So Joyce, over to you.
Thank you so very much, my Leonard Silk. I want to use this opportunity to thank SPA Ajibade Co. and our doctor for inviting me to be here today. Thank you so much. And I want to thank my Egbon, as we'll call it, and Leonard Silk, my very good friend. We have been meeting in several places. Just in 1 week, we have met in almost 5 places, and he owes me something. I've told him we'll talk about it immediately after now. I want to thank you for being the chair of the Nigerian Bar Association Legal Profession Regulation Review Committee. You did very well. And it's about regulation of our practice. My question is this. I want to ask a question. You know, it's always beautiful when you're the last person to present, because almost everybody would have said what you want to say, so you don't really have much to say again. You can just say, I adopt. Yeah, but I'm not going to do that. I'm just going to bring up something but different from what we have all been discussing. Because my question now is, why do we need to regulate the legal profession? Why did Leonard still go through all the work and his committee? Why did he go through all that to put that together for us? I have answer, and the answer is just 2. 1 is to elevate the standard of our practice in this country. And number 2 is to elevate standard of living of legal practitioners. So I see that as the 2 reasons why we are trying to get a single regulator to regulate the legal practice. 1, I will look at it. How do we elevate standard of practice? Number 1 is periodic licensing of law firms. And like most of us said, we have not been licensing the law firms. I would say I've been in the Bar Association for some time. I remember during the time of Akeredolu, SAN, Oluwarotimi Akeredolu, SAN, he introduced, based on the ROPC, he introduced the licensing, that is license for practitioners and for law firms. And how did he do that? They would check your, what do they call it? Is it your grade? How many, what do you call it? Legal, CPD points that you have generated for the year, and also the pro bono cases that you have done. Then they will issue the license. I have one, but immediately after his time, I was surprised that we don't have again. Although I think one other one tried, but it stopped. And when we came in, during our own time, we came in. I also muted that to the president because we saw some licenses in the office that people had not used that were printed. So I even muted that to the president that we should also issue licenses, checking the CPD points and other things, but we did not go ahead with that. And also we need to also institute what they call the corporate social responsibilities. And this is part of why we need to regulate the profession. One, you find out that most of the time, most lawyers don't give back to the society. And what we need to do as legal practitioners, we need to give back to the society. And how do we do that? Through pro bono, through advocacy. So we need to do that also. And then I get to number 3, which is continuing professional development. We have our brother here, Tobenna. He's doing a good work concerning that. But I know that by God's grace, we have more grounds to cover and more things to do to make it even better. And if we are talking about regulating practice and getting good lawyers in the system, we need to train them. We need to empower ourselves as lawyers. And the MBA has to come in also to empower, especially the young lawyers. There are a lot of lines of practice now that we have that we don't even practice here in Nigeria. Like, for example, some people say that the lawyers in Nigeria, we are so many. I don't agree to that. We are not many. How many are we in the country? Just approximately now, we are 139,000 lawyers called to bar. And by next year, by God's grace, we'll have approximately 5 or 6 more added to that, which will bring it to about 140,000 lawyers in the profession. So we need to train these young lawyers. We need to train them. And they need what? They need mentorship. They need mentorship. They need pupillage. We need to train them. And these are things that we need to regulate. That lawyers, before you get into the system, you don't just get into the system. What we have now is that a young lawyer will come out. There is no job. He or she would, let me start with she or he will just start practice immediately, right? We'll just start practice immediately. And when you do this, what happens? You tend to know just nothing. So we need to regulate the system in the way that these young lawyers, you have to do pupillage for 1 year. What we have 3 months from the law school. Is it 3 months? Is it up to 3 months? I think 1 month for the court, 3 months in the office, just 1 month. It's not enough for us. We need approximately 1 year to train these lawyers, because when you train them, that is what you will get. You find out that when you impart, when the senior imparts on the junior, there's a difference. You tend to flow through that line. If the lawyer is into litigation, you tend to flow through that. If a solicitor's job, you tend to flow through that. So we need to bring that up also. And then I will look at the aspect before the moderator tell me that maybe it's 5 minutes more. Moderator, how far have I gone? Have 5 minutes. Yes, 5 minutes more. Somebody should time me, because the moderator might steal some of my time. So number 2 is elevating the standard of living of legal practitioners. We find out that lawyers are not remunerated enough. You find out that clients don't think that they should pay lawyers. When they come to you, what they just feel is that you are picking up a document, adding somebody's name, maybe changing the names, and it's just the templates that you're using. But they're forgotten that, they have forgotten something, that you trained to be qualified. You're trained and you're a qualified lawyer. And being a qualified lawyer, you have a seal that you will place. Even if they try to use that template, it can be the same as yours. So they don't. And that is why I'm happy about the legal practitioners remuneration for business, legal services and representation, Order 2023, that is up now. What we need to do, it represents a positive development. The efficacy of this order is contingent on enforcement. I've been hearing a lot of people say, how are we going to enforce this? How are we going to enforce that? And that we are the ones cheating ourselves. I said, one, we need to maybe reorientation, we need it as lawyers, to let people know that we are the nobles, I will call it that way. So we need to be paid that way. We need to be paid our fees complete, not like we want to, like most of the time what they do when you want to draft an agreement, they will say maybe 100 million. There's a client I just did one for, and I'm going to send him his 10%, just to say 100 million. And then the next thing is that they will say, no, we can't pay you maybe 10% of that. We can't even pay you 1%. Want to pay you 50, maybe less than $1 million for a 100 million job? No. Thank you very much. I know, thank you. No, I'm not sure. just to, what I'm trying to say is that they want to pay you less. I think we need to make sure that we have an enforcement committee. And in your, I think in the bill, we have something like that. There's a committee on enforcement that will do that. So that is one thing that the bill has done. For that, we will need a committee to enforce this. So that once you have found, if I get somebody to write an agreement for, and the person leaves me and go to, so I will trace that person, trace that house, and find out who wrote that agreement. And once we do that, I'll report that person to the enforcement committee, and that will be handled. Thank you so much.
Thank you so very much for, again, this very insightful presentation. And I like the fact that everyone came from a different perspective. I gave all the discussants the same question, but I said, come from your perspective. And that's precisely what they have done, and added so richly to this tapestry, to this conversation. So I thank you all. I'm very, aware of the fact that we lost some time, so I'm going to try and make that up. We have another poll, online poll. That's the last of the polls that we're taking today. And the question is, should the regulatory agency for the legal profession have to wait to receive a petition against a legal practitioner before initiating disciplinary proceedings? Because currently, until there's a petition, nothing kicks in. And that's the question. Should they have to wait to receive a petition against a legal practitioner before initiating disciplinary proceedings? And the simple response to this question is yes or no. And I think the poll is open. Am I right? Tech support? Right? So please vote yes or no. Can they initiate the disciplinary proceedings themselves, or do they have to wait for a petition? So for instance, you see a lawyer, something goes viral on social media with a lawyer not behaving properly. I've seen a few where they are dressed in their wigs, well, not their wigs, but they're partially robed, or two fighting, exactly, boxing, I mean, shocking. You see them and it goes viral. And we're having to wait for the regulator, for someone to petition against them. Should that be the case? Is this what we want for our profession here? There must be a petition, yes or no? So should the regulatory agency for the legal profession? It didn't strike twice, and apparently it does. But the show goes on. The outcome of the poll, technical team, can you tell us? Can we put that poll up so we can see what was the outcome? The question was, should the regulatory agency for the legal profession have to wait to receive a petition against a legal practitioner before initiating disciplinary proceedings? That was the question. And the simple options were yes or no. Do the ayes have it or the nays have it? The nays have it. So we are actually saying that they shouldn't have to wait for a petition. They should be able to initiate disciplinary proceedings against legal practitioners without waiting for a petition. That still goes back to who's our regulator and who'll be instituting this disciplinary proceeding against one of us as needed. I'm very quickly going to tell us what's left of the program so we understand. the time requirement. There was an essay competition for young lawyers with fantastic prizes, good topic. We're going to get the results of that essay competition, the competition analysis, a presentation, and prize giving later on. But right now, it's time for Q&A. I hope you've been putting your questions out there. I'm being told by tech to hold on a moment. So what we're doing is combining the question and answer session with the panel discussion so that it can be even more interactive. And those of us in the virtual room are part of the conversation with our distinguished panelists. So this is what we're going to do next. If you haven't put your question in the virtually already, then begin to think about it. Do say who you are. If you're a practitioner, please tell us where you're attending from. So your name, your branch of the NBA, and then your question. And if you're not a practitioner, still tell us your name, tell us what you do, and then your question. If you wish to, you can direct the question to any one of these panelists specifically, including our keynote speaker. And there are no limits. You're quite welcome to ask more than one question if you want to as well. If you have comments, comments are also welcome because it's a conversation. It's an interaction. We would like to hear your opinion and your views. The topic again, regulation of the legal practice in Nigeria, charting a way forward. The regulation of legal practice in Nigeria forward. And of course, regulation, it's not just about discipline. It's just one aspect of it. We need to look at some of the things that the bill has looked at, that Prof talked about, the way we practice, where we practice, how we practice. One that's a big bee in my bonnet, what we pay the juniors, standardizing that, and making sure that they're paid a living wage. I think it's disgraceful that we have juniors being paid less than unskilled workers in this jurisdiction. So I would actually want to kick off with that by asking the panelists what their views are on standardizing the remuneration for juniors. And I'd like to start with Joyce.
Thank you so much. Like I said earlier, we need to do something about our legal practice. Concerning work payments, you find out that it's really sad that you have a law firm and they will be paying young lawyers 20,000, 30,000. From my discussion with some people, I found out that there are some people that don't even pay. They don't pay the lawyers. They don't even pay them to go to court. What they do is tell them, you are in my law firm, so you're learning, you don't need to be paid. We had this discussion with somebody yesterday, and I said, there should be regulation on how much juniors should be paid. The LPA does not have that, but I think the new bill, the proposed bill by our Leonard Silk has that we need to pay them well. I told the person, if you are maybe you are the owner of a law firm and you can't pay your junior living wage, then don't employ the junior. Do your work yourself. Because once you employ a lawyer, you are taking the person's energy.
Okay.
You are taking the person's time.
Thank you.
Thank you.
Super. Thank you for that intervention. So clearly you agree that there should be a minimum level of remuneration for lawyers. Certainly lawyers should not be working unpaid. What is your view, Chukwuka, Ikwuazom?
Thank you very much. Can you hear me?
Okay. So, my brother Tobenna talked about unenlightened self-interest. Yeah, I did. And honestly, I think that this is a no-brainer, actually, because you know what they say, if you pay peanuts, you get monkeys. It's in your enlightened self-interest to properly remunerate people who work for you. If you don't do that, you're actually shooting yourself in the foot. So I'm all for standardization of remuneration within the profession. You may not be able to legislate it, in the sense of, making it a legal obligation and enforcing it. But I think that there are innovative ways that the profession can nudge law firms and senior lawyers to pay the recommended wage. So today, if you want to become a senior advocate of Nigeria, you are asked to present evidence of tax payment. Why can't compliance with the MBA recommended wage be one of the requirements if you want a privilege, whether it is you want to go to the bench, you want to become a notary public, you want to become a senior advocate of Nigeria. So I think that this is something that we really, really need to do. Thanks.
Thank you very much. Prof. Dr. Chief, I'm interested in your views, and I'm sure everyone else is.
Thank you so much, Boma. My perspective is a little bit different. I think the issue of remuneration should be considered from the point of view of whether it should be market-driven or regulation-driven. And if you look at it a bit deeper, you would find that in terms of the market, the majority of the lawyers are not able to get good jobs. And so their income is not that good because the market structure does not favor the use of legal services, and the legal services are not delivered efficiently. When I started as a lawyer, I could bank on a brief from a bank, for instance, to recover money because I knew that the money will come back. I'll get my fees in 9 months. Because of the court process, I'll get a registry judgment. I'll enforce it within 6 months. By 9 months, I have my money inside my pocket. I could plan with it. And then later, we basically lost all the recovery cases because there were certain jurisprudence that made it difficult to get a registry judgment, and then the court system became inefficient. And then my clients started going to the police, and then later they started going to EFCC, my competitors, for recovery work. And at the end of the day, if I had focused on doing that work, I would have been impoverished, and I wouldn't have been able to pay the lawyer. So there's a tie between the market structure and your ability to give remuneration. And I think that maybe if there's better regulation of the market, of the profession, and then the profession can bring out the best value that we have, then you can be in a position to determine remuneration.
Thank you very much. I'm now going to ask Tobenna Erijiokwe what his view is.
Because I'm passionate about this point, right? The big deal of it is there's what you call collective shame. This one, 20,000 naira, 5,000 naira appearance fee, ask across the country. It's our collective shame. It's unbelievable that people earn 5% of what I pay my driver after 6 years in school. There's something that it does to our dignity, to who we are. And interestingly, how seriously we take ourselves. There's nobody on this panel has mentioned it. The MBA itself I did a very thorough, extensive work on the living wage, and my partner, Tony Moche, was the one who led on that. In fact, at the time Oduah was contesting to president of the MBA, I wrote this into his manifesto, and Chukwuka was manifesto, by the way, and Erijiokwe's manifesto, that we wanted to have a conversation about a living wage for Nigerian lawyers. Now, the argument, the other side of the coin was, what if the lawyers don't earn enough to pay? And then how do you train them to run effective businesses? So the answer to the question of what if lawyers don't earn enough was that we will look at our scale of fees and charges again. And that it was in our enlightened self-interest to make sure that we charge in accordance with that so that we earn enough to pay people that work for us. And by the way, why do you employ somebody if you can't pay them? Is this slave labor? A senior advocate was saying to me yesterday in Ibadan, I give them house, I give them car, and you're asking them to pay 100,000. I said, no, don't pay 100,000, pay 1 million, because you can command it. That's, if your firm is competitive more, pay better. We're talking about the minimum here, and we must indicate what the minimum wage is. In England, if you're doing your PP wage or your training contract, that's the minimum level that you pay people. Thank you.
Thank you very much. There is one aspect of that proposed bill that hasn't come out in this conversation, and I'm interested in hearing your views on that aspect. And that's the aspect of insurance. Yes. So if you can take it from there, quick intervention, and then I'll hear from everyone as well.
So again, this aspect of the bill makes me smile because it's something I'm used to. And I was going to make the point that even before the Solicitors Regulatory Authority came into place in England, we were regulated by the Law Society. And we had proper regulation, and people were paid their costs. And insurance and compensation, I think there are different levels. The one that they will wait or trips, and the indemnity that you have yourself. So that if, for instance, somebody is negligent and the rate of fines that negligence, even before going to court, there should be a minimum that we should pay. So we have to put our money where our mouth is. Lawyers are the ones who don't want to pay tax, they don't want to do insurance, we don't want to do anything. This is part of the education we need and the enlightenment we need to give to ourselves. And by the way, there's something that leadership should and must do. Leadership must speak truth about the issues. There is a command in what a leader says. When a leader says that the minimum wage, follow it. People will know that this is what we're saying. When a leader says you should insure, people will know that at least this is what we're saying. And I'm 100% for insurance. It is part of the discipline that we must entrench for the integrity of our profession.
Thank you very much. Joyce?
Thank you so much. Concerning the insurance, right when I was about 10 years post-call, I visited a senior advocate, can't remember the name now. He also practices outside the country. So he brought out something. He brought out his insurance policy. He said, this is what I pay outside, and we don't have it here. So I've always had that in mind. You understand that we as lawyers, we need to pay this insurance to indemnify not only your client, it will also indemnify you. Because at the end of the day, in case maybe you are negligent, instead of you being the one to pay the money, the insurance company will do the payment. So it's something that is wonderful. So I don't see anything wrong in that. It is in the proposed bill by God's grace. I think it's something wonderful that we really need to look at. It doesn't even need to be in the bill for one to be able to do it. It's just like the president can just come with the ESCO, sit down, okay, before you can get your stamp, before you can get your practicing license, because that is a condition for you to have a practicing license outside there. You must have the insurance. You must make sure that you pay the insurance policy to safeguard you and to safeguard your client. I think it's something that is okay for me. Thank you.
Thank you very much. Chukwuka, what's your view on that?
Well, my view on that is that we do that in my firm. And if it's good enough for look at everybody, it should be good enough for everybody. So I think it's something that every one of us should do. There's no regulation at the moment, but there are certain clients that you do work for, even in Nigeria, and they will demand for your professional indemnity insurance. If you don't have it, they are not going to give you work. So we are doing it already, even without any regulation.
Chief.
Well, thank you so much. Just to agree completely with what has been said, and then to look at some regulatory perspective. Part of our finding was the fact that the role of the MBA is not clear because the MBA is doing both representation and regulation. And from the discussion, you can see a lot of ideas about what the NBA will do, but those are things that relate to regulation. And the NBA will not be an independent regulator. And so for me, there's a challenge there. So why is the idea of an indemnity and insurance is okay, but it will be good within the context of an independent regulatory regime.
Should we move on to the next? Thank you very much, Chief. That's a great intervention. There is a question in the room. Please go ahead with your question.
Thank you very much.
Introduce yourself.
Yeah.
And
okay, my name is Nonso Azi. I'm the principal counsel of ASEAN as Legal Practitioners. Thank you, Chief Professor Idigbe, for that wonderful keynote address. I just want to ask two basic questions flowing from the proposed bill. What we typically hear is the call for remuneration, the call for regulation and whatnot. But I want to come from a different perspective that while we have to unequivocally condemn the poor remuneration of lawyers and for services rendered to clients, I think we should also create a room for introspection. Lawyers are professionals. We cannot close our eyes to the fact that there are concerns sometimes by clients that they don't get the standard of service that they deserve. So if the narrative is just pay us better, I deserve 10% of 100 million, which is 10 million for an agreement for land transaction, there must be a corresponding duty on lawyers that if you are to earn 10% of 100 million, you must go far and beyond the regular call in your due diligence, because something as simple as land transaction, if at all is simple, demands some quality due diligence so that at the end of the day, client is not left in trouble. So, Mr. Ikwuazom, I would like you to throw more light on that corresponding duty that lawyers have to make sure that they are always at the best in rendering services. Then, Mr. Erijiokwe, a lot of the issue of post-education training has gathered momentum over time. What I want to ask you is that, can you, in a nutshell, tell us what is the essence? Why has it become a front burner in Nigeria, and why must we get it right in that respect? Thank you very much.
Thank you very much. So Mr. Ikwuazom, he wants to know what's the value add, that commensurate value add for the fees that we demand as lawyers. And if we have
thank you very much for that question. I think that is the whole essence of this conversation, right? If you're having a conversation around regulating the profession, essentially what you're saying is, what are the minimum standards, right? You know, I talked about entry and remaining in the profession, right? What are the minimum standards for you to enter the profession? What are the minimum standards for you to remain in the profession, right? You're talking about building an independent, honest, effective, and competent legal profession in Nigeria. When you have that, then the conversation, the expectation is that clients are going to get the best possible quality of legal services. We need to understand that legal services are a public resource. You know, the same way you go to a hospital and you pay money to a doctor and you expect the best possible medical care. That's what it should be in the legal profession. And regulation of the profession is all about ensuring that not only are standards prescribed, that they are enforced, right? And then in the occasional, I say occasional because it shouldn't be the norm. In the occasional event that there's, you know, lapse in the provision of those services, that's when the fidelity fund that the bill talked about and the professional indemnity insurance that we're talking about will kick in to compensate the clients. But I agree with you absolutely that there's that corresponding duty to give the best possible quality of service to the users of legal services.
Thank you very much. I'm going to go over to Mr. Erijiokwe now to respond to the question asked directly to him.
The truth of the matter is that the most important roles that a professional association must concern itself with, even if it is paid by a professional regulator, is the training of would-be members of that profession, because it goes to the integrity of the profession, the quality that comes in. Then the retraining, and then you talk about post-qualification training, because you don't have enough from where you're coming from, right? And, there are things that we have found to happen. So there was a man that died recently, they called him Chief Osigwe. And when they listed the people who worked under him and what they've been able to build, you will see the essence of getting that grooming post-qualification. And then beyond that, your continuing professional development is critical to retaining your value. And those are the things that a profession would use to illustrate that it's actually interested in the quality of services that members provide. So this is something in England today. I don't go and say I have 18 CPD points. I actually do a self-certification. And that's even more important, to say that I am able and I've had all the training that I'm required to have in order to advise a client in this area of law. So it's so fundamental to what we do every day that the value cannot be overemphasized.
Overemphasized. I have to say I align myself with the submissions of both the Leonard Silk and Tobenna. We're coming to the end of this session. I'm going to give the lady the opportunity to ask the last question, following which we'll have a recap, and each speaker will have 1 minute to say their final word, and then we'll move on to the essay competition. Please
Thank you so much, Ma. My name is Rakiba Oloko. I'm the managing partner of Bromshi Legal. I'm also the executive secretary of Lawyers and Energy Network. So the question I want to ask is, I enjoyed today's session. It was really enlightening for me. But the question I want to ask is, we're talking about regulation, right? Regulating the profession. So how effective can we regulate this profession with the coming in of new professional associations that are springing up? If we say NBA should regulate the profession, and we now have something like the Law Society of Association. So whatever law NBA gives lawyers, some people will tell you, I'm not part of NBA, I'm part of Law Society. So how effective can we regulate this profession, so to say? Thank you.
Thank you very much. It goes to the very heart of this conversation. And I'm going to start with Chief, please.
Thank you. One of there are basically two faults with self-regulation. One of them is that self-regulation does not have the power of enforcement. The second one is that self-regulation tends to favor the members of that particular profession. So for these two reasons, there's always a need for statutory intervention, okay? And that's the driver for wanting to have an independent statutory regulator. Again, given the sensitivity of the legal profession and what it does, to ensure that it's actually independent from government control. So these are the things that have been taken into consideration in the design of this bill. And it's not really unusual to have it that way. So the professional bodies can exist, whether it's MBA on a representation basis, and whether, I hope some other organization does not come up, but even if it does come up, even in Canada where I practice, you have many professional bodies, and you can belong to anyone that you want. But the statutory regulation will be by an independent body that has the capacity to actually enforce the rules that it makes. The problem we have in Nigeria is that we have a fragmented statutory regulatory system, as I explained in my profession, and it is not effective. In some of the arguments that I've had with some other people on this, if you take, for instance, the body of ventures, and you take the General Bar Council. Okay, so the General Bar Council is actually the one that's supposed to make rules for us. And as at 2017, they had made none for the last 20 years. So really, and you take the body of benchers, they go for so many meetings, but you can't say, when you do input-output analysis, they don't actually produce any regulations, and they are not really doing anything. Even when you talk about discipline, and I didn't want to go into it, but there's something going on between whether you appeal from the disciplinary committee to the Supreme Court, or whether you appeal to the appeal committee of the body of benchers. And I have a classmate of mine who has not been able to practice for the last 20 years because of that issue. His appeal is hanging somewhere in between. So really, the system is structured, it's not working well. And in the new system, all those will be accommodated and we'll have an effective system. Thank you.
Okay. Thank you very much indeed for that very detailed response. I think it covers really all that needs to be covered. We do have some online comments, and I would like to get this. Yes, so there's a very there are comments from Oluwa Pelumi Olu Obadeji, which I think really is brilliant. You can see it on the screen there. Number one comment was concerning the issue of discipline and enforcement. There is the need for digitalization of the grievance procedures to make for easy reporting for members of the public. I think that's a very apt and good suggestion. He also has, he or she, Pelumi could be one or the other, has a second suggestion, which is concerning pupillage. Can we consider incorporating more practical levels of training in the pre-qualification stage so as to reduce the challenges associated with reincorporating pupillage? Again, that sounds pretty practical. We do have a question from Christine Oyibororo. Good day, I am Christine Oyibororo, an aspiring legal practitioner, speaking on the issue of insurance. How can insurance work in a poorly structured system, or need I say a system that barely works? For example, even in this current economy, most firms still use their old salary structure. So how best can this insurance bill work, especially for new wigs or aspiring wigs? I think I will ask who wants to take this and take it very briefly, succinctly. Yes.
I mean, so I think that there are two levels. If the insurance pay is incorporated into the practice fee that people receive, then that's fine for the individual practitioner. But I'll make the point that once upon a time, and I don't know whether the poor structure she's talking about is actually the insurance industry. A foreign company asked that we insure to a huge amount. And I was speaking to one of your colleagues and he said, we will ensure that that could collapse if you do that. So, but I think the fundamental thing is we should just start doing what we need to do in accordance with the bill and then see where we get to with it.
Yes, and it's really a question of the cup, the horse or the cart, which one comes first?
Yeah. Because
the more structured, the more confidence. But then, but I'm just moderating. Please go ahead. Let's hear from you.
Something else, Leonard. So I want to talk about work time. I think we should.
We don't have that sort of thing.
No, just 1 minute.
Okay, I'm going to give you a minute to wrap up and you get that opportunity.
Okay.
Yeah. 1 moment. We just have
not to talk about wrap up.
We have a comment from Waneamaka Anigala. I've been in a situation where the lawyer wants to act for both parties in drafting an agreement, thereby not letting the other lawyer earn a fee. So effectively acting in conflict. It goes back to regulation. What do we do with this sort of thing? It's a clear conflict. We should also uphold the standards when we see things that are below par. So no further comment on that one? Okay. All right, now I'm going to give all of our distinguished panelists a minute to wrap up. In the case of Joyce, I'm going to give her more than a minute. Yes, I am exercising that. That gender. So you'd like to start, have your 2 minutes, and then everyone has a minute to wrap up.
Really, what I want to talk about, my learner silk, is about work time. I think that should also be regulated because I've had chat with a lot of lawyers and I'm even visited some offices. You'll find out that they will resume by 8 o'clock and they will close by 10, 11 o'clock. I don't see how much you're paying any human being to be able to keep that person in the office from 8 to 11 o'clock. Because one, you're affecting the person's welfare, the person's life, you have bought over the person's life, and you can't even pay enough for somebody's life. Even if you are paying the person $1 million a month, it's not enough for you to keep somebody from 8 o'clock to 11. Then they come to work on Saturday, they go to work on Sunday. I think that should also be looked into because it's affecting a lot of our young lawyers. It's affecting their mental health and their welfare. So we need to talk about that also. We need to regulate that. I want to say thank you for this opportunity to be here. So very glad. Thank you so much.
Thank you very much. Your 1 minute, last intervention, closing.
Thank you very much.
Can you hear? Okay. Just on a lighter note, as a young lawyer, I used to keep myself in the office until 1 a.m. Nobody kept me, but I used to keep myself. So, I mean, in wrapping up, I'll make the point that the legal profession is in a critical situation. A couple of years back, I was on a panel at the SLP conference, and I did make the point that if we do not do something and very quickly, in the next 10, 15 years, the legal profession in Nigeria will become wholly irrelevant. We're seeing it already. So I think that we need to do something. The point I made at the beginning, which is that the work that Idigbe and his committee did provides a very good foundation for us to build. I think that if we're able to adopt, I'm not saying that piece of that bill is perfect, but if we're able to adopt a lot of the proposals in that bill, the legal profession in Nigeria will be better for it.
Thank you very much.
I think the word I'll use is that the legal profession in Nigeria is in crisis, and I don't even know about 15 years' time. I think we need to take responsibility, all of us, and say this entire system we find ourselves in is actually something that we should be collectively ashamed of. We need to take ownership of the profession. We need to get involved. We need to get interested at all levels. We need to do more and talk less. If we believe in something, let us put our money where our mouth is. At the Institute of Continuing Legal Education, everybody says there's no legislation, but we're doing something. We need something, do something about it. Thank you.
Thank you very much.
Thank you. Thank you so much. I just want to thank everybody for this opportunity to share the work that we did at the LPPRC. And to say that that work is still ongoing, not by that committee, but by all of us. And I would end with what Sir Clementi said, that there should be political commitment, that there should be an actual change in the law. And that means that we really need to move the needle from talk to the National Assembly, engagement, lobbying, etc. Nobody, and I want to say that nobody has the monopoly for it. So, and you can't delegate your problem to somebody else. So if it's you that is pinching, do something about it. Let's go to the National Assembly with the new bill. It may not be perfect, but it's much better than what we have now. Thank you.
Thank you very much. I must thank the audience, both in the room and virtually also. I think you need to take that fade away. It has come to the end of this portion of the program, but it is not by any means the end of the program. We have a very important segment about to start, which is the competition analysis, presentation of the prize, and that will be taken by Mrs. Bukola E.G., the moderator, and the judges. I thank you very much for the opportunity to moderate this section. of the program. I remain owner of Nigeria, senior advocate of Nigeria, Boma Alabi.
Thank you. Thank you, everyone, for staying with us. And we especially thank all participants that made submissions this year. We have 3 judges. Take a look at the submissions. Mr. Isa Alade, partner, Banwa Nigodalo, thank you very much. Mrs. Esther Jimo, Vice Chair, Lagos branch of the NBA, and Ms. Jumoke Gafar, Special Assistant to the Attorney General of the Federation. Can you join us briefly, Mrs. Jimo, just to tell us for transparency, this will just take a couple of seconds, about what they did exactly.
Thank you. Good afternoon, everyone. Good afternoon, distinguished panelists. Learned seniors here present, senior advocates of Nigeria, colleagues. So in response to the call for the essay submissions, sorry for my voice, first of all, I have cold. In response to the call, we got a total of 31 essays from our young lawyers across the country. And we had our marking scheme, and the results are all based on the contents of this scheme. And as such, we have come up with the top 6 applicants, if I can use that word. And I would hand over to Mrs. Iji to proceed with the competition. Thank you.
Thank you. The top 6, can we have it up? You don't have it. Oh, okay, yes. Thank you. So the top 6 submissions received from Eyeke Samuel, Grace Kalu, Henry Eze, Johaned Moody, Patrick Emmanuel, and Tolulokpe Idowu. Can we have a round of applause for them? Thank you. And the winner is Mr. Eyeke Samuel. Thank you very much. The prize? Okay, so congratulations once again, and thank you for your participation.
Vote of thanks. Mr. Dr. Babajide. It says closing remarks, closing remarks, Dr. Babajide Babatunde Ajibade.
I must apologize. I think it's the power problems that has made it. There's a bit of a disconnect. Well, I said at the beginning in my opening remarks that of the 16 business luncheons that we've had, I think the theme of this one is for me the most topical. And having listened to the conversations, I don't think anybody can doubt that. It might sound alarmist, but I don't think it's alarmist to say that our profession is at crisis point. And when I read Chief Idigbe's presentation and I saw the reference he made to what happened to our brothers just a few countries down the road on the West Coast, I really realized that we are close to that point. I've heard people say, when I joined the profession, it was a matter of pride to put your NBA sticker on your windscreen or put your wig and gown at the back because it guaranteed you special treatment. Now it guarantees you opprobrium because people are starting to look at us as part of the problem rather than the solution. And if we don't do something about it, we're going to have ourselves to blame. So all I can say is, it's a call to action for all of us. And I thank Chief Idigbe, my very good big brother, for such an impactful presentation and for the work that he has put into this. The other problem, and I must say it, and I said this at the last opportunity I had to speak at the Lagos branch meeting, is that we like to complain a lot in Nigeria, but complaining is easy. It is doing something about it that is a problem. But nobody wants to do something that they don't have, they want to see an immediate and direct benefit for. But they say that the greatness is the ability to plant a seed of a tree that you will not sit under its shade. And when people like Chief Idigbe contribute their time and effort to working on a bill such as the one we've been discussing, it's not because nobody paid him, as far as I'm aware. This is all voluntary work, but it's work that is done because you have a passion for seeing that things improve. And we all need to do a bit more of this. So thank you very much to everybody that has participated in this. And I will now call on my colleague, Mrs. Bolaji Gabari, who's going to give the vote of thanks. Formal vote of thanks.
Thank you, Doctor, for starting. We are indeed grateful. The law firm of SPA Ajibade Co cannot thank enough our wonderful keynote speaker, now professor, according to Madam Boma, Chief Idigbe SAN. Thank you very much, sir. It was a wonderful presentation, very eye-opening, very insightful. Thank you to another learned silk, Mr. Ikwuazom, sorry. Thank you. And also Leonard Silk, who joined online, Osigwe SAN Afam. Thank you very much, sir. Even though we were hoping to see you here physically, but we do thank you. We thank you, Mr. Tobenna Erijiokwe. Thank you so much. We thank you, Madam Joyce Oduah. Thank you so much. And thank you especially to our wonderful moderator, Leonard Silk, Madam Boma Alabi. It was such a wonderful session. We thank everybody who joined online. We thank you for staying with us despite the hitches that we had. Thank you for staying with us, and all those here physically present. We do thank you. We do not take your presence for granted. And when we do have the 17th session, we hope to see all of you here and more of you. Thank you so much.
Thank you very much. Thank you very much. The pictures, please.